Welcome to my channel, All for Health with Jane. Family, we are still on the AKA and Tibz murder case. Family, before we talking about this video, or before I present whatever that I'm going to say about this video, I would like to commit and say to you, family, I am not intending to take any sides when it comes to these cases. I will remain neutral as possible. Wherever I see that there is a problem, I am going to raise it as it is. Wherever maybe there is good things that are happening, I will raise them as they are, as per my understanding. Family, this part of the case, or this part of the court hearing that I am uploading now on this video, I am seeing, those are team defense. Let me put it in that way. Team defense, I see trouble here. I'm looking at Mr. Wolmarans. Mr. Wolmarans Ujisatimi. Because of him, the team is losing, or the team will lose this case. Team defense, I'm referring to them. In this video, we see him having attached documents that he was not supposed to attach to the affidavits of his client, accused number 4. There are some emails, communications that were between Advocate Mr. Xaba and Attorney Ms. Gillian that are attached to accused number 4's affidavit. This is a serious challenge. Hence, I'm saying, Mr. Wolmarans is scoring an own goal by doing this. So I'm just making you aware of it, and please, let's deal with the case rather than dealing with people. All I'm saying is we need to stop being personal so as for us to be able to understand and enjoy the case as it flows. Family, let's watch and listen.
Your Worship, before I deal with the application for accused or applicant number 4, I understand that my learned friend or the state is going to bring an application for the exclusion of certain evidence which forms part of applicant 4's application. So perhaps we can hear what the nature is of the application by the state, and then we'll deal with it.
You indicated, Mr. Xaba, that there was going to be an objection to applicant number 4's papers.
Thank you, Worship. That is indeed what we highlighted earlier on. Your Worship, we were fortunate to be given a copy prior to the affidavit being read on record. What we then picked up is that on the affidavit by applicant number 4, there are certain documents that are attached. The first one being emails from...
Your Worship, before my learned friend proceeds, those emails have been removed from the application, so they do not form part of the application.
I raised an issue earlier on that there are documents. I'm now relating what I said earlier on about the documents.
Why you object?
Why I'm objecting. When you reply, when Mr. Wolmarans replies, he can say, yes, I've removed this one, or whatever the case may be. I stood up and said, I have difficulty with certain documents attached to it. So now I'm given an opportunity to address the court on those documents.
I follow you.
There were email communications from Mr. Gaba, that is myself, email, official email, to Ms. Gilling. And some of my colleagues at work. Not relating to the accused before court. And therefore, there was no need for myself, as the person who was generating that email, to include any of my colleagues before court, meaning Mr. Tele and Mr. Dlamini and Mr. Mlojwa and Mr. Wolmarans, in that email. In the exchange between ourselves, I find my emails in accused number 4's papers, whereas he was not a party to that conversation, which is concerning. I'm asking myself how, for starters, did they manage to get hold of the emails between myself and Ms. Gillen? Not relating to this matter, yes, to the matter in Eswatini, but they were excluded because that email was specifically for Ms. Gillen. It's an official communication between two parties excluding others for reasons known to those parties who are party to the communication. And it was meant to be kept in that fashion. Hence, we were shocked when I saw that my emails form part of accused number 4's application. Before the matter started, I went to Mr. Wolmarans and Mr. Trede to inform them this is a problem. Hence, Mr. Wolmarans is now indicating that they've removed it. But it has to be placed on the record because I indicated earlier on my concern. The second difficulty relates to a charge sheet from another country, in particular the court of the District of Manzini, which is in Swaziland, or in the Kingdom of Eswatini. Purports to be the record of court proceedings in another country. My understanding is that Section 235 of the CPA indicates how court records can be presented in court. And it is jurisdictional in a sense that it applies in the Republic of South Africa. I'm here to understand as to on what basis a charge sheet or court record of another country forms part of these proceedings under which section. One might argue it is a public document.
Family, what's cooking here? If maybe you can explain to me what's going on here. You know, charge sheets that are supposed to be used in Eswatini court, they are attached to the affidavit that is being used in this court. Mr. Wolmarans has an explanation to give here. We need an explanation, family.
This particular court, we do not have it. What also bothers us more, on the very same document, there are notes written. Someone was working with this document, making notes of this document, indicating certain things on this document. More like, Your Worship, that my learned colleague, Mr. Twega, gives me an affidavit and say, please can you analyze this? Then I will make notes in that affidavit. So that when he gets it back, he can understand what changes he must do. It's like that. Now we are given notes of whoever thought you can attack this document because of A, B, and C, and it's given to you. The notes are not removed. The notes are there. From, I don't know how many pages are there, of an indication of how you should look at them in the critical eye of whoever made these documents. Or rather, whoever made these notes on this document. It does change materially the actual document that was handed in court. How would you tell, if the copy is not certified, that the document that is being handed in this court is the actual document that was handed in that court? Because this one now has got notes written on it. We don't know whether it's a magistrate who wrote on the paper or someone else, but from what I'm seeing, it appears that an attorney or whoever got this made reference to certain things in these documents, of which you should not have sight of that at all. But I'm still standing here not knowing who made the notes, because this charge sheet is not certified. It is on those bases that we are of the view that these cannot be admitted in this court. Unless there's anything else you wish. Oh, just a second. May I approach my pen? I'm also reminded by my partner that the document itself, the charge sheet itself, does not relate to any of these accused. It relates to other persons in that court.
In that court of Eswatini.
of Eswatini. This morning I indicated to Mr. Tele, you are attaching in accused number 2's application a copy of a charge sheet which you indicated is YY2. I said, please attach the entire charge sheet because you are attaching a court record. You cannot attach a piecemeal of a court record. I was hoping he was going to do it, hence I am also standing to say we have indicated to him that we will attach the entire court record in our replying affidavit because you only took a few pages of the charge sheet. It is the matter that we postponed earlier on this morning. The charge sheet thereof. Therefore, it is on this basis that we are saying the rules of admissibility, even though we are in a bail application, but it does not mean it's willy-nilly. Because you typify a document. I will make an example. With applicant number 2, the last document before the others were attached, it was typified or typified as a letter from the councillor, Mr. Tindimani. It's got letterheads and everything. Then you know what you're talking about. You saying I'm attaching and I'm saying this is a charge sheet. If this is a charge sheet, it then must follow the rules of how a charge sheet must be admitted in court. More so of a country that is not under the provisions of Section 235 of the CPA. On those bases, therefore, there are inadmissible portions of Mr. Kwabini's bail application affidavit, and we request that those be removed. My learned friend, Mr. Wolmarans, has indicated to me he has removed at least the emails referring to myself and Ms. Gilling. Though we're still concerned about it, but we'll deal with it as the application goes on. Those will be my submissions, unless there's anything else that my worship wants to be addressed.
No, there's nothing that I want to hear from you. My concern is, how did Mr. Wolmarans or Mr. Tele get hold of the emails between yourself and Ms. Gilling?
I have no idea.
Thank you, Mr.
Thank you.
Mr. Wolmarans.
Thank you, Your Worship. As has been pointed out, those emails have been taken out of the application.
But what was the purpose thereof in the first place?
Your Worship,
Emails that pertain to other parties other than your client.
it pertains to a matter which my instructing attorney is the instructing attorney in the matter in Eswatini.
So how do they relate to this matter?
Your Worship, I can't explain that.
Yeah.
Now, Your Worship, none of those emails in any event are marked without prejudice, but I'm not going to take that any further. Your Worship, as far as the charge sheet is concerned, around Your Worship here are 7 TV cameras. And every one of the news houses that they represent, as well as the numerous other journalists present, all know about the charge sheet and probably have possession of it. It's a public document. Everybody knows about it. The minister makes reference to it. So the Commissioner of Police makes reference to it. Mr. Kele represents the two people in Swaziland. They provided him with copies thereof. So, and the application for their extradition relates to this matter, not to some other matter, relates to this matter. Therefore, Your Worship, there is or should be no problem unless the state has got something to hide.
Yeah, but what is the relevance of Eswatini charge sheet in these proceedings at this point in time when the people concerned in that charge sheet are not even before this court?
Your Worship, that record is relevant because we all know that those people are going to come back here. And once they are back, there's going to be an application for bail. And then the same old story about, well, why wasn't it mentioned before, is going to come up. We have a similar situation.
But Mr. Wolmarans, with respect, I'm sure even if those people do come into South Africa and bring a bail application, it will not be before this court, in all probabilities.
Your Worship, the facts that have been given there relate to this matter. In any event, Your Worship, we're dealing with a bail application. The rules of evidence are somewhat relaxed. Hearsay evidence is allowed. So, Your Worship, there's another, my learned friend has referred to Section 235 of the Criminal Procedure Act, quite correctly. But there is an act which overrides that, and that is the accused's right to challenge evidence. And he's introducing evidence which challenges evidence that is going to come. We know that. So, in terms of the constitution of this country, not Eswatini or anywhere else, we are saying it is relevant and therefore is admissible, because that is the criteria, is whether it's relevant or not. And we're saying it is relevant and therefore the court should allow it. If at the end of the day the court chooses to ignore it, that's the court's decision. But at this point in time, it should be allowed. This is a bail application. This is not a trial. And in any event, Your Worship, my learned friend has not given us any authority which says that a charge sheet from another country cannot be presented to a court in this country.
But should you not have laid basis first and foremost for presenting those documents?
We're not the ones objecting, Your Worship. If I object, I've got to lay the basis. If the state object, they must lay the basis, not me. I don't have to justify what the state wants to do. With regard to applicant number 2, our learned friend has made a lot of that the entire record hasn't been attached. But if you read his affidavit, he refers only to the charges that he is facing and attaches the charge sheet. He doesn't say, I'm attaching the entire record, because that matter cannot be placed before this court and in any way influence this court, because that matter is not yet finalized. So, Your Worship, it is my submission that there is no reason why the documents attached to the applicant's affidavit should not be allowed. Unless your worship wishes to hear me on some other aspect, those are my submissions.
In reply, your worship, this also complicates things further. Yesterday, I received an email from Ms. Gilling. After I have inquired from her, from our informal discussions, where I indicated to her, we do not know as the state in South Africa or the DPP's office in South Africa, in Durban in particular, as to who represent the two Eswatini people who have been arrested. I received an email with power of attorneys signed for Ms. Gilling saying I'm representing those two in Eswatini. Yesterday. Now I'm informed Mr. Tele is representing them, hence he got these documents. It baffles me more and more as we go along. But the difficulty about this document, Your Worship, is this one little thing. It purports to be a charge sheet from another country. It purports to be a court record from another country. The authority for the admission of a court record is Section 235 of the Criminal Procedure Act of South Africa. It's not even stamped, it's not even certified to say what it purports to be. It is what it purports to be. I made an example of the councillor. We have a letterhead that says this is the office of Councillor Ndibande. What are these documents? How do we know this is the charge sheet from Eswatini? If there's no back of the court stamp to say that, I can understand the submission that everybody here has got a copy. The media people have got a copy. I don't have a problem with that. Having a copy and submitting a copy for evidence are two different things. For purposes of these court proceedings, whatever you have, it must be relevant and it must at least, according to the rules of evidence, as relaxed as they are, the problem we are having is you are submitting what you term to be a charge sheet. And you want the court to put weight on it as being a court record. From where? We don't know. Anyone can type this first page. We're not hiding anything. The papers that the DPP sent to Eswatini, we know what you wrote in those. We're not hiding anything. All we're saying is, prove the documents in the manner that are supposed to be proved. Otherwise, if you can't, they cannot be accepted. It's as simple as that. Those will be our submissions.
They are challenging the evidence you're about to present.
I beg your
No, Mr. Wolmarans waits. By the charge sheet, we are challenging the evidence the state is about to present.
How do they even know?
But those
How do they even know?
That was his submission.
Unless you can read from the crystal ball. For starters, just for starters, we might even choose not to lead an evidence. For starters, I do not understand on what basis can he make that submission. They haven't seen our papers. We have not even given them a draft. The understanding was, after the affidavits have been read on record, we will then reply. We're busy with our draft. Only that few of us knows what to contain there. He might anticipate. He might anticipate what he thinks. And what makes it even worse, the papers that purpose to be in this charge sheet are not all the papers we sent to the court. For Mr. Wolmarans to say it relates to this matter, it does not relate to this matter only, which makes it difficult now to bring evidence in a piecemeal fashion, because it does not give the proper picture that was given to Emanzini District Court. It was indicated right from the beginning, after the state has filed its affidavit, they will be given an opportunity to reply. Therefore, wait and see what has been filed and then respond, and not anticipate what you think is going to be filed. Because it might be different, you might be surprised. There might be anything at all. Therefore, wait. If you want to use this, in all fairness, follow the rules. Then you reply whatever you want to reply. It's irrelevant, as I said earlier on. Secondly, we don't know what this document is. Those are my submissions.
My ruling.
Oh, another aspect that Mr. Wolmarans did not address, my apologies, Worship. There are notes here written on this document. It worries me. There are notes, and if the court sees that, I don't know what suggestion whoever wrote the notes wanted the person reading it to think of. The contents are typed, but they are handwritten notes in this very same document. I have no idea who wrote it, whether it's the magistrate who wrote it or somebody else wrote it, I don't know. Because there's a copy attached to this document where there are no handwritten notes. There's another copy attached where there are handwritten notes, which confuses me at all. As to what was the intention to submit and attach those papers that have no written hand notes and also attach the same papers with written hand notes. I have no idea.
My ruling is that I refuse to see the charge sheet from Eswazini. They may be relevant, maybe, I say may be relevant, but I see no relevance at this point in time of Eswatini charge sheet, and I refuse to see them. And moreover, I appeal to all the court officials to adhere to the rules of fair play. This is a bail application, I agree, but the rules of evidence are applicable, and I appeal that we adhere to the rules of evidence and commit ourselves to a fair play. Thank you.
The court is.
Thank you, Your Worship. Just in response to one thing, what my learned friend, first he said it wasn't relevant, now he says it is relevant to this case, but be that as it may, Your Worship. The affidavit, of course, has to be reworked in order to remove the charge sheet and the offending documents. So, and I notice, Your Worship, that it's already 20 to 1, and I've been informed, I don't know whether correctly or incorrectly, that the court is going to adjourn at 1 o'clock because there's no water in the building.
I don't know. Nobody has informed me.
My learned friend indicates that that is the case, Your Worship. So perhaps we can roll the matter until tomorrow as set down.
Is that the position?
And we were informed about the issue that there's no water in the building. I therefore take Mr. Wolmarans' submission that we roll the matter until tomorrow.
Mr.
And as the court pleases, Your Worship, though the record reflects that applicant number 5 was supposed to be also moving his application today, in the light of the challenges that have been indicated, including, among others, the issue of the water in the building, I'm of the view that the same with applicant number 5, we can be able to proceed with this application tomorrow.
I want to place on record that I'm a little bit perturbed about the manner or the pace at which this bail application is proceeding. Bail application is supposed to be urgent, but with all respect due to the defense, there has been a delay of 2 days now due to unreadiness of the defense. I'm just placing that on record that it is disturbing on my part. But seeing that it is by agreement and due to circumstances beyond anybody's control, that the matter should be postponed until tomorrow, which was one of the days that it was set down for, the 18th, I therefore order that the matter shall then be postponed. Applicants may rise.
Family, Mr. Wolmarans says, Bona, they are very proactive. You know, they challenge evidence before it is even brought into this court. That's what he's saying. That's what he's saying. He says, we know that those 2 people are going to be brought here. And obviously, they are going to apply for bail when they come here. And before they even come, we have already started doing that. Family, let's talk. Let's talk in the comment section. What are you saying about all this? Where we find accused number, the 2 accused who are in Eswatini. Mr. Kaila says, I represent them. Mrs. Gillian says, to the state, I represent the 2 accused. You know that confusion. What are we saying about this? Thank you very much, family, for watching to the end. Please like this video before you leave. Subscribe for my channel if you haven't done so yet. I love you, family. Thank you. Bye.